The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business, Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good afternoon, everybody. Welcome to the Fourth Circuit. We have three cases on the calendar for this afternoon. The first is 19-2217 Blissful Enterprises versus Cincinnati Insurance Company. And Mr. Lawson, we'll hear from you.
Good afternoon, Your Honors. Eric Lawson with Silver & Brown for Blissful Enterprises, Inc. This is an appeal involving the interpretation of a first-party property insurance policy, and as such, it's reviewed de novo. First-party property insurance, as this court is aware, is a contract which contains a promise by an insurer to pay the insured if there is a non-excluded loss to covered property. The insurance policy in this case is 139 pages long, and it's located at the Joint Appendix at 14 to 153 or Joint Appendix 509 to 648. In this case, the main policy excludes all damage to underground pipes, but my client, a hotelier, purchased for an additional premium a special hotel endorsement that covers underground pipes that are attached to the building. The insurance company in this case and the lower court have read this policy in such a complicated way that my client could never have expected that he wasn't covered for damage to underground pipes that were attached to the building when he purchased that additional insurance to cover those specific underground pipes. Your Honors, modern insurance policies are constructed out of modular pieces, which make them difficult to read because even a relatively simple concept like adding back-end coverage for underground pipes requires rewriting multiple portions of the policy. But ultimately here, the issues are very simple. This policy covers underground pipes that are attached to the building. It covers collapses of covered property if the collapse is caused by hidden decay. And it does not exclude losses that result in earth movement as opposed to being caused by earth movement. The main policy form, the building and personal property coverage form, including special causes of loss at Joint Appendix 36, excludes from the definition of covered property all underground pipes. But the hotel endorsement, which is a separate policy form, adds back in express coverage for the subset of underground pipes that are attached to the building. And that's at Joint Appendix 113 to 114. Section
Mr. Lawson, can I ask you about that? Sorry, Judge Diaz here. So I'm following you there, but then, and I'm with you up to this point, but doesn't that loss then have to result from a covered cause of loss? And don't we then go back to the definition of what a covered cause of loss is? And doesn't that exclude losses due to decay?
It excludes many losses due to decay, Your Honor, but it's collapse caused by decay is a covered cause of loss. And you know that because when you read the main insuring clause of the policy, it says that we cover all covered causes of loss, which is defined as all direct physical risks of loss. And then unless excluded or limited. And then you look at the exclusions, and the exclusions say that collapse is an excluded cause of loss, except if it's the collapse that's referred to in the coverage extensions. And that is a collapse caused by decay, which is, it's stipulated in this case that that's what caused the loss, a collapse due to decay. So what the underlying court did is it separated out and only considered collapse in a vacuum. And then it looked at the underground pipes coverage in a vacuum. And what it should have done is said, okay, underground pipes is covered. Was there damage to underground pipes attached to the building by a covered cause of loss? And then it can look to the collapse exclusion and say, wait, there's an exception here, which is that collapse caused by decay is a covered cause of loss.
Well, Mr. Lawson, let me ask you this. Is this policy ambiguous or unambiguous?
Your Honor, I think that it's complicated, but it is unambiguous to the extent that underground pipes that are attached to the building are covered.
Well, let's assume that your opposing counsel agrees with you that it's unambiguous. And so would you agree that it's a question of law? And if it is a question of law, since there's no Maryland law on the connection between these extensions and whatever, shouldn't the Maryland Court of Appeals get a bite at answering that question first?
Your Honor,
I'm talking about certifying the question.
That would be something that would be appropriate if the issue boils down to predicting how the Maryland Court of Appeals would answer this particular issue. Yes, Your Honor. But I really do think it's so clear that there is no, the language for this coverage extension only in subsection 3 of JJ is meant to change the definition of covered property so that underground pipes attached to the building are covered property when you're dealing with a loss to underground pipes. And I think that what I'm talking about when I say that the
Mr. Lawson, so I'm sorry, Judge Diaz again. So, and why, how do you get there? Why do you say that?
Because if you didn't change the definition of underground property under the policy and you left it as not covered property, it would be ambiguous, because the insuring clause in subsection JJ of the hotel endorsement would conflict with the main policy form if underground pipes were uniformly not covered property. And so they have to, in order to make sure that underground pipes attached to the building are covered, they have to carve out an exception to the portion of the main policy form that says underground pipes aren't covered property. And that's all that definition change in subsection 3 of JJ is intended to do. And the reason I'm saying that the distinction there is that is with respect to whether or not the pipes are attached to the building, is because the underground pipes endorsement doesn't make all underground pipes covered property, and it doesn't insure for losses for all underground pipes. It only insures for underground pipes attached to the building, and you only know that if you go to section 1 of JJ and you read it in its entirety, and it says we will pay. That makes it an insuring clause. We will pay for covered causes of loss resulting in damage to underground pipes that are attached to the building. And so what the policy does is the hotel endorsement, which can be appended to any standard commercial property main policy form, and it was in this case, it needs to modify that definition of covered property to add back in underground pipes that are attached to the building. It's not.
Mr. Lawson, let me ask you this. Your expert conceded that the pipe, that corrosion impacted the pipe's ability to hold the water. Why wouldn't it be excluded under the corrosion exception?
Yes, Your Honor. So that is an issue of the application of the efficient proximate causation doctrine, which says that if there is a covered cause of loss and a non-covered cause of loss, it's still covered unless the policy has modified the efficient proximate causation doctrine by including anti-concurrent causation language. And what that means—
Does that create a question of material fact so that summary judgment was not appropriate?
I believe it would, Your Honor, except for the fact that this loss was stipulated to have been caused by collapse caused by decay. And collapse caused by decay is itself a covered loss. And so what you have is
I have a question about that, counsel. Sorry to interrupt your answer. I do want to let you answer Judge Floyd, but this is the second time you mentioned it's stipulated that the damage was caused by a collapse caused by decay. I thought the parties filed cross motions for summary judgment here, and that the insurer said for purposes of their motion, they would accept that collapse caused by decay was the cause, and they said even if that's the case, we win, but that they weren't actually stipulating to that as a fact for purposes of your motion for summary judgment, so that even if we agree with you, we'd need to remand for that factual question to be determined. Is that correct, or is there actually a stipulation I'm missing?
That is correct. I was relying on the statement made by the lower court in their opinion, which says Cincinnati accepts that the collapse issue was caused by decay, but challenges that the collapse caused a loss to covered property. And so I think that the lower court's decision should be reversed if that is true, because the collapse did cause a loss to covered property. You just need to start in the hotel endorsement when you're doing your analysis and say that underground pipes attached to the building are insured. And
But
for the purpose of that
but just
analysis,
on the straight factual question, you agree with me that and I can ask your colleague on the other side, that the insurance company has not conceded that this pipe was damaged by a collapse caused by decay, as a matter of fact.
I agree with that, with your statement,
Okay.
Your Honor, yes.
Okay, thank you.
So I think that the issue here is that the reading of the policy advanced by the insurance company and the lower court is a hyper-technical one, where instead of reading the entirety of the policy at the same time, the insurer has requested that the court conduct a two-part analysis. One, first with respect to collapse coverage, and then with respect to the underground property coverage.
So, Mr. Lawson, let me ask you about that, because that's their argument, and part of the basis for that argument is that the underground property extension coverage is prefaced by a limiting clause that makes it at least clear to your colleague that it's whatever definitions and whatever language is included in that extension applies only to that coverage extension. And what you're proposing is that the court, and that I guess you're urging that the district court should have done this as well, that you mix and match and that you blend these extensions together to arrive at a finding of coverage. But that's not, it doesn't appear that that's what the language would allow.
So I think I would dispute the statement that the prefatory language applied to the underground property extension, because it's only found in subsection 3. The subsection 1 does not say for this coverage extension only. And instead, what subsection 3
what is what is subsection 1?
Subsection 1 is the insuring clause that says we will pay for damage to underground pipes if they are attached to the building.
Okay.
And so I think you start there, and the question has to be, was there damage to underground pipes attached to the building? And if so, was it caused by a covered cause of loss? And then what you say, and because you're within that clause, you then apply subsection 3, which modifies the definition of covered property to include those underground pipes that are attached to the building, but not other underground pipes. And then you go to the start of the policy and you look to see whether or not there was a covered cause of loss. And in this case, there was collapse caused by decay. And that's
Go ahead. Go ahead, Judge Floyd, go ahead.
I mean, you say it's not ambiguous, but there is an alternating of the language for this coverage extension, and then there's for this coverage extension only used throughout that endorsement. Does that make it ambiguous, or?
Your Honor, that may be an ambiguity insofar that I believe you're referring to subsection 2 has the language for this coverage extension only. But maybe if what you're trying to explain is that there could be an ambiguity if reasonable minds can differ with respect to the meaning of the words for this coverage extension, for the modification of the definition, whereas we interpret that to mean that it's for losses involving damage to underground pipes attached to the building, and the insurer is arguing alternatively that it means limited only to that coverage extension to the exclusion of other coverage extensions. And that is an ambiguity, but it just doesn't seem like an ambiguity that ought to be dispositive against my client, because he specifically bought coverage for underground pipes that were attached to the building. And if there's a covered cause of loss to one of those, there ought to have been coverage. And that's the underlying holding that we have an issue with, is that it seems so backward that someone can have a policy that doesn't cover underground pipes, buy coverage for underground pipes attached to the building, have a loss to those pipes, and then have it be held that that loss is not covered because you're not covered for all covered causes of loss to that kind of property. That's not clearly excluded under the policy.
I mean, insurance policies do that all the time. I guess the one question, maybe you've made this argument in your papers, I don't recall, is that this is really, it really doesn't provide any coverage if read according to what the other side is interpreting it. Is that your point?
Yes, Your Honor, that is a point that we've made, that the coverage would be illusory. And I know I only have 10 seconds, but with respect to the earth movement, I think it's very clear from the expert reports that earth movement was a result of the loss, or at least that's a disputed issue of material fact with respect to the application of the earth movement exclusion. Thank you, Your Honor.
All right, thank you, Mr. Lawson. Mr. Green?
Good afternoon. May it please the court. Bryant Green for the Cincinnati Insurance Company. And what I'm here to do is ask the court to affirm the judgment of the district court to apply the plain and unambiguous language of this text, nothing more and nothing less. Now, the first issue is, first, the underground property extension does not apply because this loss does not arise from a covered cause of loss. Second, the collapse extension does not apply because there was no damage to, quote, covered property. And we didn't get into the estoppel argument today, but case law is quite clear that Cincinnati isn't stopped from asserting its coverage defenses here. Now, to start with the underground property extension, it was represented that the extension reads, we will pay for loss to underground pipe. That's not exactly what it says. What it says is, and this is at page 113 of the appendix, we will pay for loss resulting from any of the covered causes of loss. Covered causes of loss at page 38 of the appendix is defined to mean any risk of direct physical loss unless the loss is excluded. For the reasons that we've discussed, there are three applicable exclusions. One, the rust or other corrosion and decay, and that's at page 40 of the appendix, the earth movement exclusion at 38, and the collapse exclusion. Now, as we've also talked about, the plaintiff's expert concedes that this is resulting only from corrosion or decay. The analysis could simply end there. My colleague referred to the efficient proximate cause rule as a reason why this exclusion potentially doesn't apply. But what I direct your attention to is the quote from plaintiff's expert. He says, if there was no corrosion of the pipe and the subsequent loss of integrity, there does not appear to be any other mechanism to result from the exposure of the surrounding soils and they're being impacted by the flow within the storm drain. That's a direct quote. Now, what the efficient proximate cause rule holds, and actually Judge Rushing and I talked about this a little bit last month in the Joblette case, what the efficient proximate cause rule holds is that generally we're going to look for the root cause of the loss, the thing that started the chain of causation. That's what the efficient proximate cause rule is going to apply. That is exactly what the plaintiff's expert says in this case, that the root cause of the problem was corrosion. Therefore, by the plaintiff's own admission, that exclusion must necessarily apply. Additionally, the earth movement exclusion applies. Now, what's different about the earth movement exclusion...
But you don't have, I mean, your friend on the other side points out there's no anti-concurrent cause language here. So don't we need something, if you're gonna hang your hat on the expert, don't we need something a little firmer to rule out all other causes? Doesn't it need to be the sole cause if there's not anti-concurrent cause language?
So anti-concurrent or efficient proximate cause doesn't equate to sole cause. What it equates to is root cause, the thing that started it in motion. So I think it goes too far to say it's the sole cause. In fact, there is no such thing as a sole cause. You could, in a philosophy course, say that, we talked about it again in the other case, in the Paulsgraf case, about a boy throws a stone into a pond and it changes for all eternity. But efficient proximate cause doesn't mean sole cause. It means the root cause, the predominant cause. And that's what the corrosion is. That's what their expert says. But to your point about the anti-concurrent causation language, you're correct. That doesn't appear in the corrosion exclusion, but it does appear in the earth movement exclusion, that if the cause appears anywhere along the chain, that's going to apply. And then in addition to the earth movement exclusion, the policy specifically excludes collapse. Now, the collapse exclusion is at page 42 of the appendix, and it says basically that exclusion is going to apply unless the policy provides otherwise. Now, to the insured's credit, there is the collapse extension that we're going to analyze, and we're not going to hold the collapse exclusion against the insured for purposes of that coverage extension. But for the remainder of the policy, it absolutely does apply.
I don't follow that. So the insured says if we're at the underground property coverage extension, and it says we will cover losses caused by a covered cause of loss.
Correct.
So just as you're saying, we go look and see what is a covered cause of loss. And covered cause of loss excludes collapse except as provided in the collapse extension. So a covered cause of loss is collapse if it's, as provided in the extension. So we have to go to the extension to understand what does the policy cover, what's a covered cause of loss for purposes of this policy as it pertains to collapse. And then we read that and it says, collapse caused by whatever it is, hidden decay and things like that. So why is that wrong? Why, I don't understand how the covered cause of loss specifically says collapse is excluded except as provided in this extension, but then you want us not to read the extension.
Well, there's not coverage under the extension, and that's why the collapse exclusion would also apply to the underground property extension, in addition to the earth movement exclusion and the corrosion exclusion as well. So that actually brings us to part two of the argument, where we actually analyze the collapse exclusion and the collapse extension. The collapse extension does not apply because there was no loss to covered property. At page 52.
But no. We're still under the underground pipes extension, which says underground pipes are covered property. And then it tells me and losses to this covered property are covered if they're caused by a covered cause of loss. So I go to see what's a covered cause of loss, and it tells me collapse is not covered unless it is under the extension. So I go to the extension, and it describes to me what a covered collapse is. And I'm still working, we're still quote unquote under the underground pipes extension because that's where we started.
Yeah,
that's where we started our journey. So why is that not covered property? I don't see how you can cut out, well, some causes of loss don't apply to the underground pipes extension, but other causes of loss do.
But still, if you're looking at the underground property extension, we're analyzing whether collapse can be used as a reason to classify this as something other than a covered cause of loss. Even if we were not to consider the collapse exclusion at page 42, the rust or other corrosion decay exclusion at 40 or the earth movement exclusion at 38 would still apply, thus removing that whole issue from the analysis. And that's really what the lower court did, is they said, look, their own expert says that this is corrosion. The analysis could end there, but we'll continue on. We observe that earth movement applied here too. And so I don't think it's really necessary to reach a conclusion on whether the collapse exclusion applies. The fact of the matter remains two others undeniably do. But did I answer your question, Your Honor?
Well, you told me why you went under the other exclusions, but I'm not sure that you've made much headway on why we shouldn't consider the collapse extension. Okay,
so moving on to that point, the collapse extension, when we talk about what covered property is, we actually do, as you mentioned, go back and we see that under the main base policy, the business and personal property coverage form, underground pipes are not covered property, period. The way they become covered property for the limited purpose of the underground property extension is because subsection 3 says for this coverage extension, and that's exactly what it says. Now, what it doesn't say is for all coverage extensions. It says for this coverage extension with a singular extension. If it meant to all the extensions, then it would have the plural form. And it says that it doesn't actually grant back covered property status for all underground pipes. What it does is it grants back covered property status for, quote, except as provided in Section A, Coverages 5's covered extension, i.e. the underground property extension. And what's notable about that...
Mr. Green, what did they buy when they bought this extension? It looks illusory to me.
Yeah. So the legal principle of an illusory contract is basically you're bargaining and you got nothing and no promise was actually made. And the way I like to think about this, and I kind of talk about this in my brief, is if you think of it as a Venn diagram and have a circle that represents the entirety of coverage, and then another circle that represents the entirety of an exclusion, a contract is illusory if the exclusion completely eclipses the coverage that they bought. Now, that's not true here. Now, I agree with you that in this case, it applies, and I think my opponent tries to invoke the reasonable expectation doctrine, which doesn't apply in Maryland. There was just a case, the Hamilton jewelry case, decided by Judge Grimm, where that was referenced. But here, there are most certainly situations where the underground property coverage would apply. In the appellant's brief, he says underground pipes don't burn, they don't freeze, they aren't damaged by lightning, but they are. Under all those circumstances, there would potentially be coverage for underground pipes. The fact of the matter that under these circumstances, a collapse due to decay excludes it from coverage, results in the denial of coverage. But there are certainly situations in the abstract where the underground property extension could apply. Likewise, the collapse extension, there are a plethora of situations where that extension could apply, just not here. A particular note, if you look at the collapse extension, again, that starts on page 52, the extension specifically goes on to talk about specific classes of property that are covered, even though they otherwise fall into the property not covered definition. So, for example, we see that outdoor radio and television antennas are covered under the collapse coverage, awnings, gutters, and downspouts, yard fixtures, outdoor swimming pools, fences, piers, wharves and docks, beach and diving platform, retaining walls. All of these things are covered property under the collapse extension. What that does is it shows an intent by the drafters to bring certain properties that are otherwise not covered back into the scope of covered property for the limited purpose of the collapse extension. But what you don't see among those classes of materials are underground pipes. Now, it stands to reason if, like all these other classes of material, if it was the intent for underground pipes to fall within the collapse extension, then you would see that listed under there, just like all the other pieces of property as well. In fact, what the policy shows is when the policy intends to bring covered property back into the policy full stop without any limiting restrictions, the policy says exactly that. For instance, if you look at
Mr. Green, after all that explanation, it sounds like it's ambiguous to me. But I understand you're saying it's not. So my question to your colleague, your opponent, should we just certify this question because there's just no law on it?
No, I don't think that's the appropriate course of action. I mean, I think it's an available one, but not an appropriate one. And the reason is, insurance companies summon the diversity jurisdiction of federal courts all the time to resolve plain and unambiguous contract language. In fact, we're seeing that right now in the COVID cases, the COVID business interruption cases, where these cases are working their way through the federal courts and insureds want to go to state court. And this court has twice denied motions to certify those type of coverage questions, basically agreeing with insurers saying, look, this is routine policy language. The policy actually creates a flow chart for its analysis that I include in our brief. So in the very narrow sense, when we talk about issues of first impression, every case is unique. In the incredible narrow sense, every case is an issue of first impression because there's no other one like it. But we're not talking about the kind of cases that are so ambiguous that we need to send this down to the lower court for this resolution. It really involves a simple flow chart through the policy language, and we've tried to show that in our brief. So I think that I would respectfully submit that there's probably no need to certify this question. Did I appropriately respond to your question, Judge Floyd?
Yes, sir.
Now, going back to why the collapse extension, why the insert of coverage back in the underground property extension doesn't apply to the collapse extension. When the policy attempts to create a wholesale change to the policy where it's going to insert a class of property back into the covered property category, full stop, The policy says exactly that. So I'd refer you to 146 of the joint appendix, and we see retaining walls. The policy simply says retaining walls are covered, period, and stop. Similarly, there's a mandatory endorsement for gutters and downspouts where that class of property comes back in, and pollutants. Now contrast that with what we have here, where the language says only for this coverage. It doesn't say only, admittedly. It says, quote, for this coverage extension, the policy comes back in. And Judge Floyd, you raised a question as to whether there's a distinction between why the language about underground pipes didn't use the word only, but foundations does use the word only. I would submit that is immaterial for basically three reasons. One, it doesn't undermine the fact that the policy does say it only applies for this coverage extension. But two, even though foundations generally do not have covered property status, there are situations in the policy, and for instance, the civil ordinance discusses where there could conceivably be a situation where an insurance company could find itself paying for a foundation even though it's not covered property status. Therefore, the extra bolster of the word only is required to say, hey, even though there are circumstances where the policy will respond to foundation, it doesn't bestow covered property status. So I agree that that language is different. It just is immaterial for purposes of this analysis. And then really, if Blissful were correct that that the underground property extension bestows covered property status on underground pipes for the purpose of all coverages, that would really render subsections 2 through 4 of that extension meaningless. The policy could very simply just say underground pipes are covered, period, and that would be the end of the analysis. That's not what the policy says, and for that reason, the policy cannot be read as if it does say that. Finally, but before I end, I did want to address, just because the briefs mention it, there's an argument that Cincinnati is stopped from denying coverage. That argument, I would submit, is erroneous for 4 reasons. One, the policy contains a no oral modification clause. It says it can only be modified via endorsement. That's at Appendix 20. 2, the law is very clear that a waiver and estoppel can only occur when it does not create new coverage. Here, the insured is trying to rely on a email to say that coverage exists where it otherwise wouldn't. And then finally, third, Blissful has presented no facts that would support estoppel. In order to show an estoppel, you have to have a detriment. Here, from the very outset, this is at Appendix 206, Blissful was advised that the cost to explore, rule out, and confirm resulting damages will be theirs to incur. Second, the engineer was retained long before the February 2nd email. Third, Blissful did not retain a public adjuster until after the coverage question was presented. Similarly, Blissful did not retain counsel until well after the coverage denial, and so there's been no facts here that would support an estoppel. Finally, there's one case that they rely on, Nationwide versus regional electric contractors, for the proposition that an estoppel is appropriate. That case was when it was an auto case where an insured was told to go get their car taken care of, and that's the quote from it, and they did just that. They went out and had the repairs performed in reliance on what was told. There are no similar facts here, and in fact, in One Beacon Insurance versus Metro Ready Mix, this court said that an estoppel may be appropriate only if the detriment occurred simultaneously, contemporaneously with the same statement. And there's no evidence that there was a contemporaneous detriment incurred by Blissful that would give rise to an estoppel. So for that reason, there is insufficient evidence to support an estoppel either. That concludes the points that I've prepared for today. I'd happily field any other questions if the court has any of me, but otherwise I would rest on the briefs.
Thank you, Mr. Green. Mr. Lawson, you have some time for rebuttal, and I'm sorry to jump right in right away, but I do want you to address something that Mr. Green talked about midway through his argument. He made reference to this flow chart that appears at page 7 of his brief. And I have to say, you began your argument by saying this was a 130-plus page insurance policy with all kinds of different modules. And we all consider ourselves to be relatively intelligent judges and lawyers, but we don't deal with these policies all the time. And I'll be perfectly honest, this policy made my head spin when I try to, go through it. I'm not sure that I still completely understand it. But as I look at this flow chart, I'm sure you have some objections to the proposed answers in this flow chart, but it might be helpful for you to look at that and tell me where in the flow chart where Mr. Green describes the two extensions and his proposed answers to those extensions, where he is wrong and why. We can't hear you, Mr. Lawson.
Excuse me, Your Honor. Yes, I think you need to start with the proposition that an insurance company, as the drafter of the policy, has an obligation to write a clear policy, and that they can't rely on exclusionary language unless that exclusionary language is clear to an average person who, if they took the time to read the policy, would clearly understand what was covered and what wasn't. I think if you look at the flow chart on page 7, the problem I have with the flow chart is that it divides out collapse coverage extension from underground property coverage extension. I think that you need to start your analysis with the underground property coverage extension, and then when you reach the question, does this loss arise from
so I'm sorry, Mr. Law, sorry to interrupt you. Why did we start there? Because
the loss is to underground pipes that are attached to the building, Your Honor. And so if you didn't buy the hotel endorsement, you would not have any coverage for underground pipes at all. But there's a clause in JJ of the hotel endorsement that says we will pay for damage to underground pipes if they're attached to the building. So you start there. And then the analysis becomes, was that damage caused by a covered cause of loss? And it's covered if it's not excluded. So then you go back to the beginning of the policy, figure out what a covered cause of loss is, which is everything that's not excluded. And one of the things that is excluded is collapse, unless it's covered by the collapse extension, which says collapse is covered if it causes damage to covered property and it's caused by decay, among other reasons. And you can't then, once you realize that there is a covered cause of loss to underground pipes attached to the building, go back through the policy another time and say, but the definition of underground pipes attached to the building isn't modified for the purposes of the collapse extension, because you never had to leave the underground property section of the hotel endorsement. If the definition is changed, or if that was their intent, they had to say it clearly, because they have an obligation to make these exclusions so clear that a reasonable person who reads the policy in its entirety, not a lawyer, not an insurance company lawyer, and not an insurance company specialist, can figure it out. And the phrase "for this coverage extension" doesn't lead you to believe that you're not covered for underground pipe damage to underground pipes attached to the building. It just seems like it's legalese intended to mean that you are covered, and the definition needs to be changed so that it's not ambiguous, because it can't be covered property and not covered property at the same time.
Your Honor, can you address your opponent's discussion of the corrosion exclusion? That the district court said that the parties agree that corrosion was a proximate efficient cause, and why doesn't that resolve the case against you?
Because the corrosion exclusion, Your Honor, is one of several identified factors of decay or deterioration over time or latent defect. It's all the same exclusion. And so when collapse, the collapse extension says collapse caused by decay is specifically covered, that trumps the corrosion exclusion. It trumps it because corrosion is one kind of hidden decay that can cause collapse. Otherwise, you'd have issues where buildings would fall down. It would clearly be a collapse caused by hidden decay. And the judge could say, well, no, actually, because the decay was corrosion, it's still excluded under the corrosion exclusion. It would make the collapse endorsement illusory entirely.
And your argument is that the pipe collapsed, right? You're no longer asking on appeal for coverage for the sinkhole, the quote unquote sinkhole, or for the earth movement. You're saying not that the earth collapsed, but that the pipe collapsed because of corrosion.
If I may answer the question, yes, Your Honor, it's the pipe that collapsed. The experts were all on the same page that the wash from the storm caused the bottom to deteriorate to the point where the pipe actually crushed in. And it would not have been a covered loss if the pipe was just corroded, but it is when the pipe collapses.
Okay.
If there's no,
Thank you, Mr. Lawson.
Thank you so much.
Thank you both for your arguments. The case has been well presented and argued. We appreciate your arguments this afternoon. We typically come down from the bench and greet you personally. Obviously, we can't do that this afternoon, but we thank you nonetheless for your able presentations. And we'll move on to the next case. All right, the next case is 20-1640, 20-1644, DNC LLC versus Philadelphia Indemnity Insurance Company. Here's another insurance case. Here we go again. All right, Mr. Brown, you're up.
Good afternoon, Your Honor. May it please the court, my name is David Brown. I'm with Goldberg Segala firm in Greensboro, North Carolina. I have the privilege of representing Philadelphia Indemnity Insurance Company in this case. Judge Diaz, I appreciate the court's comments about not being experts after sitting here for the last argument and now knowing what you've read in this one coming in. You're going to be experts on the collapse coverage and commercial property policies here soon enough, so I appreciate that very much. Of course, this is indeed a case that involves several issues. Fundamentally, my client, Philadelphia, appeals a determination there was coverage under a collapse endorsement and a commercial property policy for a loss that occurred in Ely, North Carolina. And then we also appealed the determination that there was a willful violation of the North Carolina Unfair and Deceptive Trade Practices Statute, such that attorney's fees were awarded to the plaintiff. And then the plaintiff cross appeals the district court's determination that only nominal damages would be awarded as a result of the violation of that statute. So this loss occurred to a commercial building in North Carolina. It was a student apartment building, as the court is well aware, a 14-year-old building built in 2004, and the loss date was reported as 2018. I think the record is clear and undisputed that there were significant construction problems here. There was water that was allowed to intrude into the cavity of the breezeway, the walkway, if you will, underneath the second floor of the student housing, the apartment building. It's undisputed that the dryers, that is laundry dryers from the washer and dryer room, were allowed to vent into that crawl space. And over time, there have been significant deterioration, significant wood rot, and significant problems created as a result thereof, necessitating significant repairs that needed to be made. On the morning of January 14, 2018, there was a report that a number of students from the university had been gathered on the second floor on that breezeway. Kind of unclear in the record, candidly, how many there were, but clearly there were a number. 15 on the low end, as many as 100 students in the apartment building at some point that night on the high end. And then thereafter, there was noticed a deflection, sagging, a cracking of, again, depending upon where you look in the record, anywhere from an inch to a foot. But the pictures, I think, make pretty clear in the joint appendix that it was a deflection of, a couple of inches or so in that walkway. The claim was reported to Philadelphia. It immediately adjusted the claim, sent out an investigator who indicated that there was that in his initial opinion, the loss resulted from this long-term deterioration. Immediately, an engineer was hired. The engineer retained by Philadelphia came out, offered an opinion and a report that the loss was not caused by any sort of abrupt event that occurred, but rather was the result of long-term deterioration. And fast forward to discovery in this case, the plaintiff's engineer really didn't dispute that. So I think we've got a situation where there is an event that happened of some sort, some amount, on that early morning hours of January 14, 2018. You've also got a situation where the repairs were also needed undoubtedly because of long-term problems that had gone on due to defective construction. The district
But you
court,
don't,
sorry.
but there, correct me if I'm wrong, I don't recall there being any evidence that the sagging or cracking or collapsing or whatever we're comfortable calling it, that
Right.
that was occurring gradually over time. There was evidence that the structural integrity was being undermined, but that, you know, in a moment during this student party, the you know, the collapse, for lack of a better word, happened, that there was something abrupt, even if the structural integrity of the supports had been slowly deteriorating. I don't recall there being any evidence that there wasn't this sort of abrupt moment when things changed.
Well, the engineer, Mr. Moore from Philadelphia, whose report is in the appendix, he testified that it was not an abrupt event, but rather was a long-term event. But I will agree with Your Honor that the first notice of any sort of crack in that area was at the student party that night. I think one of the questions becomes what really caused the need for the repairs? Was it the long-term event or was it that sudden event? But I acknowledge the court's point.
Do you contest that? Oh, sorry. So the collapse, I'm a little perplexed by this. The additional coverage provision says it only applies to abrupt collapse, which it defines as abrupt falling down or caving in. But the exclusion above that refers to collapse, not just abrupt collapse, which I guess we should take to mean falling down or caving in that may or may not be abrupt. And I was looking in your brief to see where or if you dispute that this was a falling down or a caving in. Is that something that you know, for purposes of the exclusion and the exception to the exclusion, do you contest that this was a falling down or caving in, that this was a collapse for whatever that means under the exception to the exclusion?
We do dispute that. We do
Okay.
dispute if there was a falling down or a caving in. And if I may, and I appreciate the court coming right to the heart of it. So the district court found that there were 3 exclusions before we get to the collapse endorsement that would bar coverage under the policy: the decay or deterioration exclusion, the faulty workmanship exclusion, and the long-term water exclusion. That's at appendix 658, kind of footnote 5 on the district court's initial order. That has not been challenged, not disputed, not appealed. So any one of those exclusions standing alone would be sufficient to bar coverage for this claim. So the way to the coverage exists.
Well, you say that's not appealed, but the district court didn't find that those barred coverage because they don't have anti-concurrent cause language, as we talked about in the previous case, right? The district court said that there is coverage. The only one that does the defective construction, actually defective construction goes on to say, even if there's a covered cause, it would be covered. So what do you mean it wasn't appealed?
Well, I guess the point is that the only route to coverage here is through the collapse endorsement. In other words, if there was not, we don't contend the collapse exclusion applies. The question, I think, for the court is whether the collapse endorsement that affords coverage that otherwise would not exist under the policy applies or not. And I think
didn't the district court say that they both applied? Am I misremembering that? The
district court did indeed find that coverage was created via the collapse exclusion. You are correct in remembering that. And we fundamentally contend that coverage cannot be created via an exclusion. That coverage is created through insuring grants and then pared back through exclusions, and then can be reinstated through an exception to exclusion, but that fundamentally the route to coverage is through a grant of coverage.
Mr. Brown, I'm a little further down the road than you are. Let's assume the judge was right. But as to he's right about he's right about the unfair trade practice, why shouldn't that be vacated and the damages that are equal to the contract damage be part of the calculation, so that let's just assume it was $300,000. Then you go to the unfair trade practice, which he found. Why shouldn't that have been trebled? Which would also take care of the attorney's fees, because it seems to me this is just like I understand he can't recover on both, and so it's just a classic election of remedies. So didn't the judge err in just awarding a $1 nominal damage in the unfair trade practice?
No, not at all, Your Honor, because the North Carolina Supreme Court answered this very question in the Gray case, the Gray versus Jordan underwriting case from 2000 that's discussed at length. That very issue was before the Supreme Court, and the Chief Justice Frye's opinion in that case considered the very argument that's been made by the ENC here and that the court just outlined. That is, what damages get trebled. And what the Supreme Court held is that the legislature intended for the phrase "treble the amount fixed by the verdict" to mean that damages proximately caused by a violation shall be trebled, not that damages on every claim that happens to arise in a case involving a Chapter 75 violation shall be trebled. The court has stated that in order to recover treble damages, the plaintiff must show what injury he incurred as a proximate result of the violation. So in other words, in order to recover treble damages, a successful litigant has to not only prove all of the elements of the claim, but then prove what damages were proximately caused by that violation. So now that brings us to and begs the question of what was the violation found here? Because as you know, there was a bad faith claim where summary judgment was granted for Philadelphia and not appealed. There were allegations that
Mr. Brown, can I ask you a question about, sorry, this Judge Diaz, about that? So, I mean, subsequent to Gray, there have been a number of Court of Appeals opinions that have talked about UDTPA claims in the context of what, for lack of a better term, I'll describe as an aggravated breach of contract, where there is a breach of contract, but then there are attendant circumstances that serve to aggravate that breach. And the courts of appeals have held, notwithstanding Gray, in some instances citing to Gray, that in those instances, because the attendant aggravating circumstances are part and parcel of the breach of contract, that those in fact can form the basis for a trebling of damages. Isn't that what we have here?
Respectfully, no, it's not, Your Honor. I think what the cases have held is that if the unfair act caused the claim to be denied, so if Philadelphia engaged in some sort of unfair act that was found either as a matter of law or submitted to the jury and found by a fact finder, that it did something unfair, deceptive that caused it to deny the claim, then potentially the contract damages could be trebled. But here, the district court found, correctly so, that there was an honest disagreement as to whether there was coverage or not under the collapse endorsement, and consequently granted summary judgment for Philadelphia on the bad faith claim and on 3 of the 4 unfair trade practice alleged violations, finding in favor.
But you don't have to have bad faith in order to recover under an unfair trade practices case, do you?
You do not, and you have to find willfulness in order to afford attorney's fees, and so that's one of our contentions, is that there's not the requisite willfulness here to award fees. But the court's right, you don't have to have bad faith to have a violation, Chapter 75, but what you do have to have is you do have to show what damages were caused by that violation. And to Judge Diaz's point, cases that have found that the contract damages get trebled have always been cases where there was something unfair or deceptive in the denial of the claim itself. And here, the violation that was found, bearing in mind the court found in favor of DNC on 1 of the 4 alleged violations, the violation that was found was a failure to properly explain the position in a denial letter. The violation was not the denial of the claim. The violation was that the denial letter itself was somehow viewed to be confusing, and that the insured had to then, figure out what was meant by that letter, which eventually was done thereafter. But the point is, Judge Diaz, the damages, I think the courts have been have been extremely consistent, both in in state court and in the federal courts applying North Carolina law, that contract damages do not get trebled unless there was something unfair or deceptive in the very denial of the claim. Otherwise, what an insured has to prove is the damages that were proximately caused by the unfair act. So I think Judge Eagles was right on the mark in tying the need to the question of whether damages can be trebled to a finding of what was unfair. And what was found to be unfair was the denial letter. Nothing more, nothing less, but the denial letter itself, not the fact of the denial, but the fact, the argument was that the denial letter was somehow confusing. And as a consequence, that's what was found.
Well, not just confusing, but deceptive, right? Unfair. Well,
I guess I'll just abide by what the district court said, which is that it was violation of subsection N of 5863-1511. But I guess the point here that I want to say is that if you look at the Gray case, it was a hurricane claim. The hurricane was not an unfair trade practice. How the insurance company handled the hurricane claim in certain respects was found to be an unfair trade practice. In that case, the contract damages did not get trebled. Here, if there was a collapse, which we dispute, the collapse was not an unfair trade practice. So whatever damages were caused by that don't get trebled. Rather, there has to be some showing of damages that were approximately caused by the unfair act was found in order to treble those damages. And I see I'm out of time for now.
Thank you, Mr. Brown. Mr. McDougall.
Good afternoon, Your Honors. Thank you, David Brown. Appreciate it. Mr. Brown made two statements. Courts found treble damages if the wrong conduct is in the denial itself. Here, the wrong conduct was in the denial itself. A letter denying coverage with 9 different misrepresentations, citing the actual wrong provisions that were amended, citing provisions that left out. It only cited the exclusions for the collapse, but not the coverage provisions for the collapse. It also said things like flood may have occurred. Well, there was no flood at Elon. He admitted that. He said boilers may have caused it. There are no boilers at this facility. He admitted that. He went on and on and on, and there were 9 different things. He said, no, that had nothing to do with it. And the best, his boss looked at flood and said, what was he talking about? If you look at it carefully in the letter, he cites the wrong collapse provision that was amended by endorsement, and the entire collapse provision was completely gutted and amended. This Mr. Gertling from Colorado, for some reason, sent that. If you look at it real carefully, though, he then cites the exclusions in the new amended collapse provision that was provided.
I have a question about that, counsel. Judge Rushing. So the provision of the N provision that you prevailed under requires a reasonable explanation of the basis for the denial. And you have to, in the explanation, you have to cite the policy provisions and the facts. What about the letter was not an explanation of the basis for the insurer's denial? I understand they had extraneous provisions they didn't need to include in the end, but they explained the facts and they cited the collapse provision under which they think coverage should be denied. Now, even if they're wrong about that, that was the basis for their denial. How is this a violation of Section N?
As the judge pointed out, and as I point out, not once did they talk about collision and, collapse applying to anything in the policy. What they did is they took the exclusions and they even put number 1. So the exclusions start in a section with a number 3. So if you see a 3, you know there's a 1 and 2 that precede it. So it says B3 is what he cited, and those are exclusions. 1 and 2 are coverage provisions. So if you see,
Yeah, he didn't cite, he didn't, yeah, I'm
But-
totally accepting. You're right that the letter didn't quote the entire insurance agreement, and there may have even been misrepresentations, right? There was a provision that's not even in this policy about fungus or something,
that's
right?
from another
But
policy.
you didn't prevail under the misrepresentation provision of North Carolina law. The court found you didn't win under that.
Because
And there
there's
is a
no-
separate provision for misrepresentations where you rely on it or something, and there's no evidence of that. The only thing in front of us on appeal is whether there's an explanation for the basis of denial in this letter. And it looks like
then there wasn't. So you have the Rule 58 and the questions, I'll just give, I mean, it goes, the letter is unbelievable. If you look at it, it doesn't tie any provision of the policy with any of the facts. The judge said that over and over. She said it was a convoluted mess. And
well, it says long-term water intrusion and deteriorated wood framing, the result of an improper installation of dryer vents and failure to install water management systems. And then it cites all the provisions of the policy, I think, that have anything to do with water, because it thinks that this was caused by a water management problem. And it cites parts about deterioration and fungus and things like that.
I apologize for interrupting.
Yeah,
But
it's
what
hard to
they
hear
have
you when you talk over me.
They have to tie the policy language, though, into the facts, and they never did that. They just cited.
Why do they have to? But they do both of those. What you're saying, they need to cite the provision after the sentence where they explain why you're denied, and that's why it violates Section N?
If you read it closely, it just says the following exclusions appear in the policy. It doesn't say how flood is involved. It doesn't say how boilers are involved. They're just sending it out to basically.
So you're saying that's not a reasonable explanation for the basis of the denial?
Absolutely.
If they explain why they denied it and they cite the policy provisions, but they don't go on to, for each provision they cite, they don't give an additional explanation of, the reason why we're citing flood to you is X, that North Carolina requires that level of explanation, is what you're saying.
Some level of explanation. There was none. There was nothing.
What's your best case for the level of explanation North Carolina requires? I haven't found any. I could use some help. I really could use some help from North Carolina on this.
I found a middle district court that had absolutely just said, we're denying the claim. And they said that's a violation.
Right.
Similar to this, it says we're denying the claim on flood. It's, the intent, obviously. And the judge said this. What else would be the intent of putting in boilers when there's no boilers on the site? Flood when there wasn't a flood in Elon in years, if ever. And he just says, I put it in because I wanted to. Well,
I'm not sure that takes away the explanation in the letter. The question is, was there an explanation? Even if you have all these extraneous things, they might be misrepresentations, but you lost on that and you didn't appeal it. But I don't want to take up all your time on this because you need to argue about why coverage.
Judge said misrepresentation takes reliance. Our provision does not take reliance. So she ruled in our favor. We don't have to show reliance. Many courts have already said that. And what's the catch-22 here is, okay, you send out a letter like that and the policyholder looks at it and says, I have been deceived. I'm not going to go anywhere. Okay, I believe the insurance company. What happens? They go home. They lose $450,000 because they.
And if you've been deceived, there's a provision for that. But this is just about whether they gave an explanation, even if the explanation was wrong. But it's an explanation they believed and they gave it.
And it's one of the regulatory. I mean, it's actually a statute that you have to do this. And the effect of it is, one, that person's going to believe it and not understand it. I mean, this thing is unbelievable. It only has 3 pages of policy language, and then it has constant changes over and over and over, 150 pages. And the normal person, I mean, I've been doing this for years. I couldn't understand it. And for him then to get a letter with all this stuff, he's going to say, I don't understand it. But what's important, 2 weeks before that, he received a letter from a vice president, home office, Grimoire, Philadelphia, saying, you have coverage and we will be paying your claim. No retraction, no reservation of rights. He thinks that my claim's going to be paid. They have yet today say that doesn't count. So we've got a letter saying we're going to be paid. Then they send a letter that makes no sense saying you're not going to get paid. And we're going to cite all
Mr.
these
McDougall,
things.
can I ask a question about the Supreme Court's decision in Gray, because your colleague mentioned that case is dispositive on this issue of trebling damages. And as I understand his argument it's that because his client was entitled at least to contest the issue of liability on coverage, that any damages that flowed from the manner in which they contested the coverage, and you've outlined that in the letter, all the things that they said in the letter that I think I would agree with you don't seem to make sense, but that wasn't the proximate cause of your client's damage. It was the denial of the coverage, which they were entitled because the court didn't find any bad faith liability that they were entitled to deny. And so that's what makes Gray dispositive on the issue of treble damages. What's wrong with that argument?
First of all, Gray says there were no aggravating factors. It went to the jury, and the plaintiff's lawyer sent the interrogatories, never asks, are there any aggravating factors? And also they didn't ask, is this one continuous transaction with a breach of contract and the, mailing the letter with the person who made a claim that the property, they had a lien on the property. So there's all these different actions, but nobody even talked about it. The interrogatories, but they did say, in my opinion, there was no egregious conduct found, so therefore they could not treble the breach of contract damages. They trebled, as a matter of law, as you do, the unfair and deceptive $117,000, but not the breach of contract because nobody asked. And so then after that, as you noted, there have been Court of Appeals, several Court of Appeals decisions. Fourth Circuit Bartholomew says the same thing, that you get treble damages. So there's three different ways to get them. And the law right now is not clear which one, but you do get them. You get the continuous conduct. It's a continuous transaction. So what Philadelphia states, DNC has not come forward with evidence of any injury or damage that resulted from the alleged statutory violations, separate from the damages that resulted from the alleged breach of the policy by Philadelphia's denial of coverage. Trying to separate it out. Okay, you have a breach of contract for $401,000 plus interest of $67,000, and then you have the unfair and deceptive trade practices that if they believe you, they go away and there's no lawsuit. If they don't believe you, they're going to say there's no reliance, there's no damages. So the statute's a nullity according to them. So then you look at, okay, we have not come forward with any evidence. Well, it is one continuous transaction. And the continuous transaction has been recognized since Miller v. Miller, long time ago, 1980, one of the seminal cases, says you need a continuous transaction. You have breach of contract and you have unfair and deceptive, and they are related. Then you have a continuous transaction. You have Harlock versus Henson, same thing. Over a 3-year period, guy goes to a broker and says, sell my truck, sells his truck, tells him, I didn't sell your truck, I didn't sell it. He sees it one day being driven by another person and says, I'm going to sue you, I want my money for my truck. He gets to sue him, wins, and they give him the money for the truck and they give him unfair and deceptive trade practices. And what they do is treble the breach of contract. It's all one, you can't separate it. So the damages, proximate cause damages, are all related. I think somebody earlier used, the circular method. If they're overlapping, you have a continuous transaction. What could be more continuous than a denial letter that contains the unscrupulous behavior, that their only hope was to make these people go away. And if it doesn't work, then you say, well, we don't have trouble damages, nothing to lose. We know we have coverage, or don't have, we know we have coverage. So why not take a shot at throwing this letter out there and maybe it'll go away? They're going to do it in the industry. Every single carrier.
Counsel, can I want to ask you a question about coverage before your time runs out. What is the relationship between additional coverage, point 3, that additional coverage does not apply to a building that's standing? What is the relationship between that provision and the exception to the exclusion?
Exception to the exclusion creates coverage because it says it's an all-risk policy, and North Carolina recognizes when an accident has more than one cause, one of which is covered by an all-risk.
Yeah, I understand that. I'm asking you, so the exception to the exclusion says collapse can be covered in certain situations.
Weight of people.
Then the additional coverage section says collapse is also covered in these other certain situations, but it says this additional coverage does not apply to a building that's in danger of falling down or caving in, or a building that's still standing, et cetera. How does that provision, talking about still standing or not having fallen down or caved in, but in danger of it, how does that relate to what it means to collapse under the exclusions and the exceptions to the exclusions, which are in a different, they're not under additional coverage collapse, but they're both talking about collapse. How do those relate?
We have additional collapse is any part of the building. Now this pan fell down. How many feet does it have to fall down to make it fall down under this policy? It doesn't say. So then they say, okay, is it? I guess that means that it hasn't fallen in or caved in. It's in danger. Danger means future. It already caved in. There is part of the breezeway that's on the ground. It caved in and it went to the ground.
So you're saying this definition of collapse, this expanded definition in part 3 that says it doesn't apply to things that are still standing, you think that applies to and defines what it means to collapse under the exclusions in section 1?
I think it's as ambiguous as can be. I don't know what it means. All I know is it's not going to take away coverage when you have ambiguous, whenever you can, in North Carolina's most favorable insurance coverage for the policyholder in the country. And it says if you can find coverage, you have to find coverage. If there's any doubt that there's an ambiguity, there's an ambiguity. This is ambiguous language. They have to.
Okay, thank you.
Okay, going back to the unfair and deceptive trade practices. So you have that.
Mr. McDougall, you're over your time, so I'm going to have to stop you. You're over your time. Mr. Brown, you have some time left for rebuttal.
Thank you, Your Honor. I'd like to first begin on the question Judge Rushing was just raising. The endorsement, the collapse endorsement, has two components and they stand alone. The first part of it is the exclusion. So if you take the collapse exclusion and out of the endorsement and put it on the base policy, that would be applicable if we were trying to deny coverage based upon the collapse exclusion. We're not trying to deny coverage based upon the collapse exclusion. So therefore, that first portion, including the exceptions to the exclusions for weight of people, et cetera, is irrelevant. What is relevant is the next section. Yes.
I appreciate you trying to help me sort this out, but can I ask you to assume hypothetically against, I know you don't think that section 1 applies, but if I thought it did, if I thought that the exception to the exclusion there was, provided coverage, how do I define collapse under that exception to the exclusion? Do I look to the additional coverage provision to help me define collapse, or is that prohibited because it's a different section? I'm not sure.
No, the gateway to coverage here for the insured is without question under the collapse endorsement language before you. So the way, if there is coverage afforded here, it necessarily has to be afforded under the coverage grant for collapse. And so therefore, subsection 3 of that modifies everything having to do with collapse. So therefore, there is no collapse unless the building has fallen down or is in danger of falling down. A building that is standing, or any part of a building that is standing, even if it shows evidence of cracking, bulging, sagging, bending, leaning, settling, shrinkage, or expansion, is not collapsed. So very succinctly, that's where we hang our hat that there's no coverage here. It's barred under the exclusions and policy that we discussed earlier that Judge Eagles identified. The only route to coverage is through the collapse endorsement, and the collapse endorsement, none of it can afford coverage if the building is still standing, even if it has cracking, bulging, sinking, expansion, et cetera, which is what we have here.
What about the fact that the building was condemned 2 days later and it's not occupiable?
And it was condemned because of the 14 years worth of water intrusion and wood rot that the engineers identified. That's why it was condemned, not because of anything that happened abruptly on that night.
Well, Mr. Brown, that's not accurate because it would not have been condemned but for what happened that night. There would have been no reason for them to know about it.
Well, it was known about. It became manifest that night. I agree with you. And whether it became manifest because of the crack, or whether it became manifest because they happened to have a building inspector come by, or became manifest because someone said, this seems to be a little bouncy as I walk across the breezeway, let's look at it. Whatever caused the damages to become manifest then led to the need for the repairs due to the long-term corrosion. I agree with you that the events of that night create a manifestation date, if you will, but that doesn't in and of itself create coverage. Let me speak to the letter, if I might. The letter, of course, is in Appendix 438, and the letter that's in question, and let's just big picture here, what we're talking about is, can the plaintiff not only find coverage, but treble the contract damages because there's something about this letter that is in violation of subsection N, failing to properly provide an explanation. The context here is Philadelphia investigates this claim promptly, gets an engineer out there promptly. Within a month, or a month and a week, they've done quite a bit of work on this whole project. They go through all the engineering reports. They identify the policy provisions. They don't hide the fact that there's a collapse endorsement. They cite the PU ULT 142 on page A 441. They don't hide that. There's nothing deceptive about it. And at the end of the policy language, they say, we respectfully must deny coverage because the damage is reportedly the result of long-term water intrusion and deteriorated wood framing. Then they go on to say at the bottom of that page, we trust your understanding of our coverage position is clear. However, should you disagree, please promptly communicate with us. So there's nothing, there's been several suggestions here today that somehow Philadelphia was trying to get the insured to go away and leave them alone and not come back, et cetera. And to the contrary, this is a very prompt claims investigation, an explanation that we're denying coverage for a very specific reason. Did it cite policy language perfectly? No. Was it written by legal counsel after much analysis? No. But this was a good faith attempt to explain to the insured what was going on. There was no willful violation. Attorney's fees and a violation of the statute should not have been found, and certainly the contract damages cannot be awarded based upon the letter. Thank you.
All right, thank you, Mr. Brown. Thank you both for your arguments. The case has been submitted. We would typically come down and greet counsel. We can't do that this afternoon, but we appreciate your.
I think according to the rules, because it's a cross appeal to both those appeals, I have a 5-minute rebuttal.
You're absolutely right. Go ahead, Mr. McDougall.
Thank you very much, Judge Diaz. So one thing is they did not cite the exclusion because they didn't cite the part that provided coverage here where water damage is mentioned, and weight of people was mentioned. And so don't say that was cited because it's not there. And then additional coverage collapse, you only cited the exclusions that you referenced earlier, and the other 1.5 pages were left out. And then you numbered it wrong by number, you being your client. I'm sorry, David, not you, but number one, but I'm changing 3 so you know that something preceded it. So that was not cited in the policy and was never discussed in the policy. And it's clear that there's coverage under weight of people in section 1. That's all you go to. It's not complicated. And going back to the unfair and deceptive, so you either have a continuous transaction, there's many cases that say if you have a continuous transaction and with a breach contract and it's related to the breach of contract, then you have treble damages. There's also cases that say if you have aggravating circumstances, you get treble damages. Gray says there were no findings of aggravating circumstances, so there could be no treble damages in the breach contract. Some reason the plaintiff's lawyer asked the interrogatories the way he did, and they never found aggravating circumstances in breach contract. They found aggravating circumstances in the $117,000 of probably the claim where they were sending the check to because they asked the first thing, what's a breach contract? And then they were sending the check to somebody who had a lien. So that one says it does not have aggravating circumstances, so you couldn't have treble damages in Gray. After Gray, the Court of Appeals on 4 occasions found aggravating circumstances and said if you have aggravating circumstances and a breach of contract, you take them together. You don't separate them, and you don't have to say, okay, I want approximate cause for this event. I want approximate cause for that. No, it's one event. What are the damages? It's simple. And I can go through what Judge Eagle said. She said there were damages. She actually said there were approximate cause of damages. On and on. She said, it's undisputed that Philadelphia did not pay anything on a valid insurance claim. So DNC has proven that Philadelphia approximately injured DNC. So 3, you have to have the unfair and deceptive trade practice affecting commerce, approximate cause. She says right there's approximate cause harming DNC. And then finally, she says the same injury forming the basis of plaintiff's breach of contract claim is also sufficient for the purposes of an unfair and deceptive practice claim. So she's already ruled that we should be getting treble damages. And for some reason, she issued an order without any statement. It's just 1 page. It says, I'm only going to award nominal damages. And there's no explanation. So also, you have the continuous transaction, you have the aggravating circumstances, and you have the per se violation. And the per se violation has been interpreted to be the language, I believe, is unfair. So if you have a statutory violation, Rule 58, such conduct is inherently unfair, unscrupulous, immoral, or injurious to consumers. So the question is, as a matter of law, per se violation, you don't have to show aggravating circumstances because that language is the same as aggravating circumstances. And it's saying as a matter of law, it's immoral, unscrupulous, and you look at the regular packaging case, concealing a breach combined with acts to deter further investigation is enough to show aggravating circumstances. So you got aggravating circumstances, you have whether or not a per se violation, and a continued transaction. So you have all these cases that show basically it's simple. If you have a breach of contract and you have unfair and deceptive trade practices that relate to the breach of contract, then you get treble damages. Or else the statute would have no effect whatsoever. And the public policy is basically written in Marshall is you need to have a remedy. And that's why the legislature enacted the statute, and it's very clear.
Mr. McDougall, you're a little bit over your time. I'm going to let you say another sentence or two, then I'm going to have to stop you.
the purpose of the statute is supposed to be for remedial, for other reasons, private enforcement, and the fact that it provides a remedy for aggrieved parties. Well, if we take the defense, David Brown's argument, there would be no remedy. And the purpose of 75.1 is because, and this was written Marshall v. Miller, Supreme Court, Unfair Deceptive Trade Practice Act was needed because common law remedies had provided ineffective remedies. For example, proof of actual fraud involved heavy burden of proof, including a showing of intent to deceive. So that's why they enacted it. And the purpose of 75.11 by the legislature, and I'll end on this, to declare and to provide civil legal means to maintain ethical standards of dealings between persons engaged in business and between persons engaged in the consuming public within the state, to the end that good faith and fair dealings between the buyers and sellers at all levels of commerce be had in the state. Sounds pretty good to me. That's the purpose of the statute. And that's plaintiff's position is have to have a remedy. And you have a remedy throughout all these different laws.
All right, thank you, sir. All right, the case has now been submitted. And again, I thank counsel for their arguments. We typically come down from the bench and thank you personally. We can't do that, obviously, given the circumstances, but we nonetheless appreciate your arguments. And I'll ask thank you, counsel. I'll ask my colleagues if they're okay continuing. Judge Floyd?
I'm good.
Judge Rushing?
Yes, thanks.
All right, thank you very much. Good afternoon, counsel. The next case is People for the Ethical Treatment of Animals, Inc. versus North Carolina Farm Bureau Federation. Mr. Broad, is it? Did I pronounce that right?
It's Broad, Your Honor.
I can't. Broad, okay.
That's okay.
Mr. Broad, you may proceed.
Good afternoon, Your Honors, and may it please the court. My name is Nick Broad. I'm in the North Carolina Department of Justice, appearing on behalf of the Attorney General and the Chancellor of UNC Chapel Hill. The right to exclude is the most fundamental attribute of private property. The North Carolina Property Protection Act seeks to codify and strengthen that right in a statute that's patterned after this court's decision in Food Lion. The district court below was wrong to strike down the act under the First Amendment for two reasons. First, the act doesn't implicate constitutionally protected speech, and therefore the First Amendment doesn't apply. And second, even if the First Amendment applies, the act is content neutral and passes intermediate scrutiny. The decision below should therefore be reversed. I'd like to start with the text of the act, which is reproduced at addendum page 3 of the blue brief. And I want to start in particular with subsection A, if I could. Subsection A is the law's substantive prohibition, and it gives property owners a civil cause of action for damages against anyone who exceeds their authorized access to enter non-public areas of the owner's private property. I want to pause there and flag two attributes of subsection A that I think are critical to keep in mind right off the bat. The first is that subsection A gives a civil cause of action to every property owner in the state. This is a law for everyone. It applies whether you are a business, a medical clinic, a house of worship, a homeowner, a political campaign. This is a law that is generally applicable and regulates the property rights of all individuals throughout the state. The second feature of subsection A that I want to flag is that this law only applies when someone is intentionally in the non-public areas of someone else's private property. The statute defines non-public area to include those parts of private property that are not open to the general public. So this statute only comes into play when someone is intentionally in the most private areas of someone else's private property.
Mr. Broad, wasn't this statute, I mean, isn't it pretty clear from reading news accounts and the legislative history and all that, Yet all this statute was is to prohibit news gathering activities that constitute speech.
Your Honor, the text of the act doesn't say anything about news gathering activities. It doesn't target the media. It doesn't target any particular industry. As I said, this is a law for everyone. The text of the act is decidedly facially neutral. I think you can resolve this case by reference to the text of the act alone. To the extent that Your Honor's question is asking about the legislative history that's in the record, I'm happy for you to consider it because I think it supports my arguments. I think representative after representative in the legislative history stood up and justified their support for this act because they thought the act would strengthen protections for property rights. And you can see those citations to the joint appendix collected at page 49 of the blue brief. I think the legislature.
Can I follow up on that? So I think you focus on Section A of the statute, and I think you're right to do that because, I mean, read in isolation, that seems to be a statute of general applicability with no reference to anything other than an attempt to protect and preserve property rights, which the legislature is well within its authority to do. But, I mean, you have to read the whole statute, then you get to subsection B, and there are a number of examples in there that pretty clearly are intended to combat the very types of activities that I believe my colleague, Judge Floyd, was referencing in those news articles and the concerns of the legislators. So don't we need to consider the entire statute?
Your Honor, I agree that you need to consider the entire statute. So let me turn to the specific provisions that are at issue in subsection B. So subsection B defines 5 ways in which an individual can exceed their authorized.
Can I ask you a question about that? Is this intended to be exclusive, or are these the 5 sole ways that you can violate this statute?
Your Honor, we understand B to be exclusive, that these are the sole 5 ways of violating the statute. And I think this case has been litigated on the assumption that B is an exhaustive list. I don't see anything in the text to indicate that it might be non-exhaustive. So the provisions that come into play in B, the provisions that have been challenged here, B1, 2, 3, and 5, are only implicated, again, when you're intentionally in the non-public areas of private property. And I think that matters because the district court here was very focused on what the act prohibits. The district court explained, for example, that recording in the abstract is speech. And I don't disagree with that. I agree that recording is speech within the day-to-day meaning of that word. But the district court didn't ask, I think, a second critical question, which is not only what the act prohibits, but where the act prohibits it. And because this act comes into play only in the non-public areas of private property, this act does not implicate constitutionally protected speech. It might implicate speech within the day-to-day meaning of that word. It might implicate speech within the way that we colloquially use that word every day. But it doesn't implicate constitutionally protected speech because it takes place in non-public areas of private property. And let me give you.
Do you have any cases, Mr. Bro? Do you have any cases that holds that speech in non-public areas is unprotected?
Yes, Your Honor. The Supreme Court's decision in Lloyd against Tanner, I think, makes clear that you do not have a First Amendment right to go onto someone else's private property to engage in speech. I mean, the individuals in Lloyd wanted to go onto private property to distribute handbills protesting the Vietnam War. I mean, handbills protesting the Vietnam War is the core of the core of the core of political speech. And yet the Supreme Court held that that was not constitutionally protected speech because it took place on private property without the owner's consent. And I think Lloyd—
Mr. Broad, can I ask you about Lloyd? But Lloyd wasn't a case of a government-imposed restriction on speech. That's what we have here. And so I don't have a quarrel with the notion that someone as a general proposition doesn't have a First Amendment right to speak privately freely on private property. But the question is whether the government, the state, can impose enhanced penalties for someone who is inclined to engage in that activity. And that seems to me where the district court focused its attention with respect to the First Amendment. So what about that?
Your Honor, I think the statute doesn't implicate constitutionally protected speech because it's giving a cause of action to a landowner. I mean, the landowner is in the driver's seat. It isn't the government that's in the driver's seat here. The landowner is making decisions about who comes onto their private property and for what purpose. I mean, the right to exclude is a right that goes back before the Constitution. It antedates the founding. It's a right that all of us exercise every day with respect to our own property. And the court in Lloyd was trying to square this ancient common law right to exclude with claims of a right to access private property under the First Amendment. And the court held that you do not have a First Amendment right to go onto someone's private property without their consent, even if you're trying to engage in speech, even if you're trying to engage in archetypal political speech, as was the case in Lloyd. I mean, I think the way the Supreme Court resolved this tension between the right of access on the one hand and the right of speakers on the other hand is to say that your right to speech goes up to and until it interferes with the peaceful possession of private property, which is the interest that the tort of trespass seeks to protect. And I think that resolution is consistent with a general principle that animates a lot of our law, which is that your right to swing your arm ends where someone else's nose begins. I mean, I think that's the core teaching of Lloyd. I think the court's analysis in Lloyd also took account of the fact that property owners have constitutional rights too. Property owners have Fifth and 14th Amendment rights to their private property.
Mr. Broad, aren't those rights already sufficiently vindicated by the statutes that are on the books as well as the common law protections against trespass? So what's the point of this statute other than to suppress the very kind of expressive activity that Judge Floyd was describing?
So two responses, Your Honor. I think first, I don't think that question is relevant to this threshold issue of whether the First Amendment applies.
That's fair enough. Yeah, that's right.
So if you're in First Amendment world, then I think that question is definitely relevant. I think the existence of alternative ways at getting at this conduct, so trespass or other common law or state statutory causes of action, actually helps my argument because it shows that this statute works like a sentencing enhancement. It takes conduct that is already tortious, that is already prescribable, and it allows a landowner exercising their right to exclude to recover enhanced damages for conduct that the legislature, I think, reasonably decided was particularly injurious to private property rights. I think the sentencing enhancement analogy is a really helpful way of thinking about this law. And I think it's borne out by looking at the real world way in which the act has been applied. So I want to make sure that this hasn't gotten lost in the briefing, but if you look at pages 49 to 50 of our response reply brief, we collected some examples of how the act has actually been used by North Carolinians in federal and state courts. And I think those examples provide really good support for this idea that the act functions like a sentencing enhancement. In those examples, plaintiffs are invoking the act along with other state law, statutory and common law causes of action to vindicate their property rights. So this statute,
well, you could have different applications of this act. For example, trade secrets or non-disclosure agreements, things like that. But the focus here is on speech, and so when you talk about the Fifth and 14th Amendment protecting property rights, well, it does. It protects against the government taking it without just compensation. It doesn't do anything more than that.
Your Honor, I don't think that the focus of the law is on constitutionally protected speech. I agree, as I mentioned earlier, that it does concern speech within the day-to-day meaning of the word. But because the act is only implicated when you are intentionally in the non-public areas of someone else's private property, I don't think that is speech that the First Amendment protects. I think in that situation, and again, I think this is the core teaching of Lloyd, in that situation, the rights of the property owner trump any access right that an individual might claim under the First Amendment. I think that's how the Supreme Court has, again, resolved this this core tension between the law of trespass and the right to exclude on the one hand, and the First Amendment on the other hand. I mean, again, I think you see this error repeated multiple times in the district court opinion. The district court focused its analysis heavily on taking these provisions kind of in isolation without situating them geographically. And I think that ignores the geography of the First Amendment. I mean, I think the First Amendment has a geography to it, like many other constitutional rights have a geography. Constitutional rights have a different scope depending on where you are in the world. And I don't think the First Amendment is any different. I think the cases are clear that the First Amendment does not grant individuals a right to access private property where they don't have the landowner consent.
Speech has never been exempted because of its location, has it?
Your Honor, I think whether something is constitutionally protected speech does depend on where the speech is taking place. And again, I would point you to Lloyd. I mean, distributing handbills protesting the Vietnam War, it undoubtedly is constitutionally protected speech if you're doing that in a public park. But the Supreme Court held that when you're doing it on private property without the consent of the landowner, it is not speech that the First Amendment protects. And because this act only applies when someone is intentionally in the non-public areas of someone else's private property and engaging in activity that they're not authorized to engage in, I don't see how any of the challenged provisions under the statute implicate the First Amendment. I mean, just to give you a few examples, I mean, I think if you asked a first-year law student whether it's a tort to install a hidden camera on someone else's private property without their consent, I mean, I think there's only one right answer to that question, and it's yes, of course it's a tort. That's subsection B3. I think if you ask the same question with respect to whether it's a tort to substantially interfere with real property, yes, of course it's a tort. That's these common sense, common law principles that the Act puts into a statutory prohibition to give private property owners a meaningful...
Can I ask a question, sorry, about the whistleblower aspects of this statute, which your colleagues have been concerned about? And I want to put this in the context of some recent whistleblower activity. I assume you have seen the news stories of Frances Haugen and her whistleblowing activities with respect to Facebook. If Facebook were headquartered in North Carolina and able to utilize this statute, would they have a cause of action against Ms. Haugen for her activities under this law?
Your Honor, so my understanding is that she has disclosed the documents that she disclosed pursuant to federal whistleblower protections under the Sarbanes-Oxley Act and the Dodd-Frank Act. And I read this statute not to apply to federally protected whistleblower activity. I think there's two reasons for that. One is just federal preemption. I don't think the state can impose civil liability for federally protected whistleblowing activity. But two, I think, is the term duty of loyalty in B1 and B2, the employer-employee provisions. I think, as this court explained in Food Lion, that's a common law duty, and it's certainly subject to exceptions, including the exception that no employee has a duty to conceal criminal conduct or unlawful conduct or general misconduct on behalf of their employer. So to the extent,
why wouldn't that apply to someone who admittedly misrepresents the status of his or her principal purposes and is hired as an employee? Once an employee of the company, doesn't that employee have the same duty to ferret out misconduct?
Yes, that's true, Your Honor. And this statute has nothing to say about employees who make misrepresentations to gain employment. I mean, the statute was patterned after Food Lion, and Food Lion made clear that just because you make a misrepresentation on a job application, that doesn't automatically turn you into a trespasser. So there's
no, I guess I think you misunderstood my question. Isn't that trespasser, admittedly a trespasser,
yes,
engaging in the same kind of whistleblowing activity that a Frances Haugen was engaged in, for example?
If that person were engaged in federally protected whistleblower activity, I don't think that the state law that's at issue here could impose civil liability on that individual.
Well, let's put the federal statutes out of it. Let's just say there's no federal statute that applies, but there's some strong public policy interest in ferreting out whatever the misbehavior is. And in the context of the agricultural, farms and development, it's the alleged abuses and practices. And, they may dispute that, but let's assume that they've uncovered that kind of activity, which either law enforcement or a legislature might be interested in. Isn't that the very kind of activity that, society as a whole wants to promote, that kind of whistleblowing activity? And doesn't this statute deter that?
Your Honor, I don't disagree that whistleblowing activity is critically important. I think in figuring out whether someone has violated the text of the statute as it's been written, I think you're asking questions about how are they gathering the information and what is their intent, and how are they using the information and what is their intent. And I think the particulars are just going to depend on the facts of the case, but you're asking questions about how and why and where, not questions about what they are saying. You're asking questions to decide whether this act applies about how individuals are conducting themselves in the non-public areas of someone else's private property. And I think the analysis in any particular case is just going to have to proceed through those questions that are set out in subsections B1 and B2 and the other challenge provisions of the Act. I do want to make sure, if I could, to preserve the time that I have left.
Certainly, Mr. Broad. Thank you very much for your argument. Mr. Maraskin?
Thank you very much, Your Honor. David Maraskin for plaintiffs. And I'm going to endeavor to reserve 2 minutes for our rebuttal. The defendants are asking you to create a never before heard exception to the First Amendment. And what's yet more head scratching about this is even if you created it, it wouldn't solve their problem here. And so I want to take each of those issues in turn. Judge Floyd, you're absolutely correct. When the Supreme Court has talked about exceptions to the First Amendment, like in RAV, they've talked about categories of speech, not locations of speech. No one has ever said that speech on private property is exempt from the First Amendment. To the contrary, the Supreme Court in Watchtower applied the First Amendment to a restriction on a licensing scheme that prevented people from going on to private property. And the circuit courts have repeatedly applied the First Amendment to restrictions on speech, and particularly restrictions of recording on private property without permission. That's Wasden, that's Shark, it's the district court decision in Herbert. And what Mr. Broad is failing to acknowledge before the court is his entire Lloyd line of argument has just been discredited by the 10th Circuit in Kelly, which is the most recent 28J letter we submitted to you. What the 10th Circuit says correctly is that Lloyd stands for the proposition that an individual can exclude someone from entering, and that non-expressive act of excluding them from entering does not require First Amendment review. That's what Lloyd says. But what the 10th Circuit goes on to explain is that when that non-expressive conduct, the restriction on entry, is joined with a restriction on speech, which is true with B1, 2, 3, and 5, then First Amendment scrutiny may be required. And indeed, the Supreme Court in Holder, this court in American Life League, the Third Circuit in Barnicki, the 10th Circuit in Western Watersheds Project, all say that when the state joins a restriction on speech with a restriction on conduct, First Amendment scrutiny is indeed required. This exception simply doesn't exist. And what, as I said, the other part of this is that defendants are simply wrong. This will solve any of their problems. So in response to you, Judge Diaz, my colleague said that it doesn't matter what the purpose of the statute is. That's wrong. Even under Kelly, what the 10th Circuit explains is that even if you were to believe there was such an exception to the First Amendment, and there is not, when a statute is viewpoint discriminatory, as is true of this statute, it still requires First Amendment review. And you certainly can look to the legislative history and the text of the law to determine that it's viewpoint discriminatory, that the purpose of this act is to prevent speech that would be critical of an employer and to allow speech that would laud an employer. That's exactly what the 10th Circuit and Kelly found was viewpoint discriminatory. Further still, they simply read out several elements of the statute. So even if Mr. Broad's correct that we look and see that some of the conduct occurs on private property, and again, I would dispute whether this is a private property interest that's equivalent to the private property interests that were referenced. The Ninth Circuit and Medical Center explained that non-public areas like these are in fact don't have a privacy interest the same way a home does. But leaving that aside, that a lot of the speech that's regulated here is public speech. If you look at B1 and 2, they restrict the use of information after it's gathered. As the district court explained, use encompasses the public communication of information, exactly the whistleblowing that you described, Judge Diaz. And so the notion that this private property exception would salvage this law, again, is just head scratching. The
Counsel, can I ask you a question? We haven't mentioned or talked much about Food Lion yet, but it does bind us. You make a passing reference in your brief, something to the effect that there have been cases after Food Lion. I wanted to follow up on that and ask you if you think Food Lion has been undermined. Does it constrain us? And if it constrains us, what should we do here?
So if I can give you a two-part answer, Judge Rushing, to that. Our reading is that Food Lion is entirely consistent with our view of the law. The passing reference was if you were to give Food Lion the misreading that defendants advocate for it. So let me try to explain what we think the correct reading of the law is and then where we think defendants' misreading would have been overruled. So Food Lion, in our view, stands for the unremarkable proposition that if the state restricts non-expressive conduct and speech proves that non-expressive conduct, the First Amendment doesn't apply. And that's Wisconsin v. Mitchell. And you can look at Food Lion itself to make very clear that the court there thought it was regulating non-expressive conduct. So in page 515 to 16, what the court describes the duty of loyalty tort that it thought it was applying. And what it says the duty of loyalty tort that it thought was applying was having two employers and committing an act to benefit one employer rather than the other. We certainly don't dispute that was shown through a recording in Food Lion, but there was that.
Well, in the
act.
court, I mean, the point of my question is not about Food Lion generally, but about the First Amendment analysis in Food Lion, where the court says this is news gathering, and there are First Amendment protections for news gathering, although it's not may or may not be speech itself, but it's news gathering in aid of speech. But we still don't think that the entire failure to do any First Amendment analysis is a problem in a case like this. So what do we do with that part of Food Lion?
Well, I actually think, Your Honor, with respect, this goes back to the tort. If you look at and the very specifics of Food Lion, so if you look at page 522, for instance, which I think is what you're referring to, that's where they do their First Amendment analysis. And what they say is they understand the tort at Food Lion to be like Cohen, the Supreme Court case in Cohen. And unlike the Supreme Court case in Barnes, Cohen is a breach of contract case. And so what they're equivalent to, it's a non-expressive act being regulated. News gathering, just like in Cohen with promissory estoppel, that was a case in which.
So I don't think it was breach of contract, was it? It was, but they're applying the concept from Cohen, right? That a generally applicable law, there's not a license to violate generally applicable law when you're gathering the news, right? You can't promise to keep a source secret and then break that promise and claim, well, I'm allowed to break the promise because I'm a reporter. And so the analysis in Food Lion was if there's laws against trespassing and bugging someone's property, you can't, bug someone's business and say, well, I'm a reporter and it's news and get an exception. So what do we do with that?
Well, so again, with respect, Your Honor, that's not, I believe, a correct reading of Food Lion. Our understanding of Food Lion is that the tort there was the equivalent of having two employers and working for one to the detriment of the other. There was no there's no element of the tort in Food Lion that was about bugging. Bugging happened to be what was going on in Food Lion, and though that bugging happened to prove the underlying activity of having two employers and working for one but not the other, but that does not, the actual elements are what drive the First Amendment analysis. If you have a statute that has elements then you apply the First Amendment. If you have a statute that doesn't, you don't apply the First Amendment. And this had no speech elements. And so then that's why I think the Cohen analogy is so important. What they are talking about when I'm analogizing to Cohen is that this is like promissory estoppel, exactly like what you were describing, Judge Rushing, that the newspaper has no obligation, or excuse me, no right to breach an agreement with a source, because that agreement with the source is a contract, and a breach of contract is a non-expressive act. And that's different than to say that the state has the right to restrict reporting, which is how defendants.
What do you do with? And you're right that there are important distinctions here, and I'm trying to make sense of, the Supreme Court in Zimmel gives an example of, there's the fact that you can't go into the White House for any reason doesn't mean that that's not a First Amendment violation, because you'd like to go in there and gather news that would be very important to understanding, what's going on in our nation, because there's no First Amendment right to violate the generally applicable exclusion. How does that sort of analysis apply here when we have a statute that excludes people from private property and prevents them from doing things that are particularly invasive, right? Like placing cameras, secret recordings, stealing information?
Well, Your Honor, so I think what's going on in the passport case is, again, about non-expressive conduct. They're saying that this government can restrict, at Zimmel, that the government can restrict where they'll authorize a passport to go. The fact that that restricts speech does not in and of itself raise First Amendment concerns. Similarly to your entry point, and this is the Lloyd point, the state can restrict entry and the individuals can restrict entry. That's established non-expressive conduct. The problem here is that they've joined that with restrictions on speech. And this is the Western Watersheds, Aptive, Kelly line of cases that all say that when you join a restriction on conduct with a restriction of speech, that then implicates the First Amendment. And
weren't those cases dealing with statutes that weren't as general as the one we have here? I seem to recall that there was, some of them were about what you say in particular, or just about certain facilities and just about certain content. And I realize that that's once you get into the First Amendment analysis, right? That's assuming that the First Amendment's implicated. But it struck me that those were not quite on point with what we have here in a more general statute.
Well, so I think this may also go to answer your earlier question, which we haven't kind of gotten to yet, about what if you were to read Food Lie in the way, it sounds like you may be reading it, and certainly the way defendants read it. I do think it's been overruled. It's been overruled by Holder. So Holder's a case, and I'll point you to page 28. They say the law there is directed at conduct, not speech, conduct. And the law there was to, certainly as important an interest as protecting property, was about preventing people from working with foreign terrorist organizations. And what the court says is, even though the law was directed at conduct, the aid to foreign terrorist organizations, if the conduct triggering coverage involves speech, again, this is at page 28, then the First Amendment applies. Here, the conduct triggering the statute, as it is written, is speech. It is reporting, which is either a speech.
Mr. Maraskin, I'm sorry. Let me ask you about that. So your colleague on the other side began with the statute, and he began with subsection A, which he described as a broad statement of protection of property rights with respect to non-public areas of an employer's premises. So if the statute had said nothing more than that, I suppose it might be subject to some challenge for not being specific enough or vague. But if that is all that it said, would it not effectively encompass the very activities that are then delineated in subsection B and achieve the same result?
Well, in such a statute, then, Your Honor, might be subject to an as-applied challenge if it were applied to news gathering and public communication. It would be turn on what the act that exceeds the person's authority means. And as written, I think I agree with my colleague that facially those words alone don't, to my mind, trigger speech. One would think that it's things, as Judge Rushing mentioned, like theft. And if that's how those statutes, that's the only way in which that language was applied, just to theft, I don't actually think there would be any First Amendment concerns.
Well, but I guess my question is, if that's true, then why is it a problem then that the legislature has gone on and identified 5 different ways? And this gets to my question maybe of whether or not this was intended to be exclusive, because in Food Line, as you concede, the act that triggered liability was expressive conduct, but it wasn't necessarily part of the statute that was being implicated in Food Line, because there the claims were for trespass, fraud, etc. So why wouldn't the same result obtain here if we simply had a statute that broadly talked about acts in beyond the person's authority to engage in, and those acts, you seem to concede, could well include elements of expressive speech? What's wrong with the legislature simply identifying what those elements are?
So I think maybe I'm not being clear on 2 fronts, Judge Diaz. So I do want to make very clear about 2 things. One is that we are saying Food Line only covers non-expressive conduct, not expressive conduct. In our view, Food Line is solely about having 2 employers and doing the work for one and not the other. And that's how they get to the Cohen-Barnes distinction on page 522. I would agree with you that if the act that exceeds the person's authority were interpreted only to mean conduct by the courts, that would raise no concerns. But what I was trying to say was, if it were interpreted to apply damages to speech, to these actual acts in B, then you would get a as-applied First Amendment challenge. The reason we're able to apply this challenge facially is we know everything that A covers. It covers what's in B. And, and again, just to kind of highlight this Food Line issue, the damages in Food Line was for $1 for the breach of duty of loyalty. It wasn't for the reputational harm that was caused by the videos being aired. And that's because the actual tort was the tort of working for ABC, not making the recording. Here, the recording showed that you were working for ABC. It wasn't the act that was being regulated. Here, the actual act of recording is being regulated. And, I also think, Judge Rushing, to go back to your question about Food Line being overruled, no court has read Food Line the way defendants are asking it to be read. To the contrary, they've consistently given the reading that I am offering you. That's the DC District Court in Project Veritas, the Iowa District Court in Reynolds, the District Court below here. They've constantly seen Food Line to be about non-expressive conduct, not speech. And if you were to read the Food Line line of authority, you'd be creating a split with a variety of circuits. You would have to split with the Ninth Circuit, which has held that recording on private property that's unauthorized is protected speech. And in fact, that statute violated the First Amendment. You'd have to be splitting with the Eighth Circuit's most recent decision in Reynolds, which is the Eighth Circuit appeal of that Iowa case, where they said that the fact that a statute has an intent to commit an unauthorized act on private property does not prevent the First Amendment from applying. That's page 788.
Mr. Maraskin, assume that we agree with you and intermediate or strict scrutiny applies in this case. Is there a way to sever the statute in order to save part of it if we agree with you?
Thank you, Judge Floyd. So the answer is that we've already done that for you. We are not challenging subsection B4, and that section certainly survives. There is potentially ways to, so on subsection B5, we believe the harm to ownership, which is where we focus our attention, not the harm to property, which is where defendants focus their attention, is the problem. Ownership, as distinguished from property, seems to encompass reputational harm. If it seems very similar to the statute at issue in Kelly, which is where there was harm to the enterprise, and the court in Kelly said that that was reputational harm. And so you could sever the word ownership and just leave the word property in subsection B5. So there are ways for that provision, and you could keep B4. The other ones, Your Honor, because speech is so intermingled with the statute, I don't believe you could sever them. But I do think your point is well taken. To your earlier point, I recognize the amount of time that whether intermediate or strict scrutiny applies, the law falls. And so once you reach the scrutiny analysis, the law falls. And that's why they so focus on this non-existent exception to the First Amendment. I'd like to reserve the remainder of my time.
Thank you, Ms. Maraskin. Mr. Broad?
Thank you. One brief point on severability, and then I'd like to go to Food Lion. The district court below held that each of these 4 challenge provisions were severable from one another, that they could operate independently. So to the extent the court has concerns with one particular subsection in B, I think the other ones could operate independently. The district court held that, and I don't think anyone's challenged that on appeal. I do want to talk about Food Lion because I think Food Lion is maybe the most critical case in this appeal. I think that if I had to summarize the holding of Food Lion, I would summarize it along the lines of what subsections B1 and B2 of this statute say. Subsections B1 and B2 were guided by this court's decision in Food Lion and prohibit individuals from going into the non-public areas of someone else's private property, gathering information in a way that's unauthorized, and then using that information to commit a breach of the duty of loyalty. That's exactly the type of conduct that this court held in Food Lion is not entitled to First Amendment protection, and it's why the act does not fall under the First Amendment here. This court held in Food Lion that the torts of trespass and the breach of the duty of loyalty, the torts that are codified in this statute in B1 and B2, are generally applicable torts, and you do not have a right under the First Amendment in the service of gathering news or gathering information to break generally applicable laws. And so I think Food Lion controls the interpretation of subsection B1 and B2, both in terms of how you understand the statutory provision and also how you understand the First Amendment analysis that applies. My friend on the other side mentioned the Holder case and argued that Holder has overruled Food Lion. Holder is an as-applied First Amendment challenge to the material support statute. I mean, everyone in Holder, and you can see this at footnote 5 of that case, everyone agreed, including the government, that there was some constitutionally protected speech that was at issue there, and the only question was the level of scrutiny. In Food Lion, by contrast, I mean, this court held that the torts of the breach of the duty of loyalty and of trespass, as applied to undercover video reporting, were not protected under the First Amendment at all. So I don't think Holder overrules Food Lion, and I certainly don't think it overrules it with the kind of clarity that this court ordinarily needs to overrule circuit precedent as sitting as a panel.
Can I ask a question about Food Lion? You talked about the breach of the duty of loyalty. Do you think that duty of loyalty is sufficiently defined for purposes of gauging what falls within or outside of the First Amendment protections in the statute?
I do, Your Honor. I think the district court was correct to hold that the duty of loyalty does have a sufficiently definite meaning, not to cause or not to raise constitutional concerns. The district court looked to this court's decision in Food Lion and the North Carolina Supreme Court's decision in Dalton, and said that those two cases and the related cases, the North Carolina cases that they cite, provide sufficiently concrete guidance for individuals to figure out when you breach a duty of loyalty. I mean, I think the core of the duty is in the Food Lion style situation where you're working for two employers who have adverse interests, and you deliberately acquire an interest that's adverse to one employer and that benefits another. I mean, there might be other circumstances in which the duty could apply. For example, if you're working for an employer and you develop an adverse interest and start your own business. But I think the cases are sufficiently clear not to raise a constitutionally significant amount of doubt about the meaning of the term duty of loyalty. And again, I think for purposes of the First Amendment analysis, the key teaching, the key holding of Food Lion is that duty of loyalty is a generally applicable rule, that you do not have a right under the First Amendment to violate. Because
just to follow up sorry, you began your argument a long time ago, not that long ago, but with the notion that the statute, even if it does implicate First Amendment concerns, doesn't do so doesn't offend the Constitution. And I think you made reference to news gatherers and the fact that it wouldn't implicate news gathering capabilities. But doesn't the joint liability provision in this statute cause some concern? I think there have been briefs filed that suggest that might sweep up a broad swath of otherwise legitimate news gathering ability.
Your Honor, my time's expired. If I could answer.
Well, since I asked the question, I think you can go ahead.
Thank you. The district court interpreted subsection C to apply only in the context of someone who has a specific intent to engage in, for example, a civil conspiracy or civil aiding and abetting style agreement with other parties who have violated B. So the district court reasoned that subsection C does not independently raise First Amendment concerns, that subsection C could be enforced consistent with the Constitution to the extent that the challenged provisions in B are constitutional. And I think that makes sense if you look at the district court's actual injunction order, which doesn't say anything about subsection C. I mean, the order that the district court entered only enjoined the 4 provisions of subsection B that have been challenged here. And I think consistent with this court's precedent, the district court reasoned that it isn't a First Amendment problem to impose civil liability under a conspiracy theory or aider and abetter theory to the extent that the provisions in subsection B are constitutional. And with that, I respectfully request the court reverse the judgment of the district court.
Thank you very much.
Thank you.
Mr. Maraskin?
On page 522 of Food Lion, the court there says that the statute does not get First Amendment scrutiny because an activity covered by the law does not necessarily involve expression. We have here activities that are covered by the law that do necessarily involve expression. We have recording that has been held to be in and of itself expressive and a protected predicate to speech. We have use, which has been held both by the district court and by the Supreme Court in Sorrell to mean the communication of information to others publicly. We have subsection 5, which governs reputational harm through dealing with harm to ownership. Food Lion simply doesn't apply. It's dealing with a very different type of statute. And defendants, I think, are trying to show a bit of confusion with this use of generally applicable law language. Generally applicable law has been used 2 different ways in the case law. One is that it refers to statutes that don't regulate any form of speech. They're just aimed at non-expressive conduct, like promissory estoppel and co. The other is that it's been regulated, statutes that can regulate both conduct and speech. And as this court in American Life League very clearly explained, when it's the second type of generally applicable law, one that can both cover conduct, pure non-expressive conduct, and speech, then the First Amendment applies. That's the same holding as in Holden. So even if you were to include this as a generally applicable law, because of what the elements cover, it's protected by the First Amendment. Defendants reading that this is just the duty of loyalty, as in Food Lion, reads out the fact that B3 and B5 don't mention the duty of loyalty. It ignores the fact that in their own briefs, they say, well, it's the duty of loyalty element. Sorry, Judge Rushing, yes.
Counsel, what's your, we've talked a lot about the sort of use of the information, but I wanted to very briefly touch on B3 about placing an unattended camera, a surveillance device. What's your best authority for a First Amendment right to bug private property? As the state pointed out, this would even apply to a home that has employers. So what's your best authority for a First Amendment right to secretly record everything that happens in someone's home?
So, Your Honor, I just want to be clear about what the statute says. It's not just place, it's place and use. And the end use is very important because the act of recording, it used to record. Using that
device to record.
Yes, yeah.
Yeah, so what's your best authority for a First Amendment right to place a private camera in Judge Diaz's house and secretly use it to record everything that happens there?
So our best case would be Wasden, which specifically covers that. It then would be Reynolds, which in the Eighth Circuit talked about engaging in unauthorized acts and engaging in speech. And I want to make a very clear distinction because I know where you're pressing, Judge Brushing, and I understand it. There's a difference between saying the First Amendment applies and the First Amendment prevails. They're trying to get off the road at step one because they can't win any of the other steps. But if they regulated placing a recording device in Judge Diaz's house, that would be very different. It would be much more tailored. And you could clearly see why such a statute might survive First Amendment review. This is not such a statute. And I'd also point out that subsection 3 isn't even limited to private areas. Unlike the other ones that talk about going into—
Sure it is, by Part A. It's limited by Part A.
So with respect, that's not how we read it because it doesn't have the same language that B1 and B2 do about going into on areas without authorization. But even if that were true, non-public areas are not the same thing as private areas. That's the Ninth Circuit's medical center decision, where you have a property where you have invitees who are willing to come in, which is true of non-public areas. They don't have the same privacy interests. But Wasden is my simplest answer to you. It covers recording on private property.
So you don't see a distinction. You are pressing for a First Amendment right to access private property, including private homes, and record secretly.
No, Your Honor, I want to be very clear. I'm saying the First Amendment would apply to such a statute.
And you think you win on this statute, right?
On this statute, but if there was a statute that said, no, you cannot secretly record in Judge Diaz's home or in any home, I won't make it specific to him, I think that would be a much more tailored statute and one that likely would survive First Amendment scrutiny.
So what's the difference? This one says you can't secretly record on private property, which includes homes and the private parts of businesses.
Well, and this goes to the scrutiny analysis, which we haven't talked about a lot, and I recognize them over time, but I just have a moment to walk through it. I think that what's problematic here is that there's no distinction that you're drawing. They haven't said, they said below, pages JA 11 and 12, that there are 3 goals to the statute: prevent theft, prevent entry, prevent undercover investigations like that my clients engage in. If you want to prevent theft and entry, the way you do that is you restrict theft and entry. There's no need to restrict speech. If there was a history of people recording in private homes, that would supply the evidence that's required under McCullen and would be tailored, and so it would survive First Amendment scrutiny. That's very different than saying that the First Amendment doesn't apply. And I think the First Amendment would apply to that statute. I just think it would survive.
Okay, thank you.
Thank you, counsel. I recall some years back, seems like years ago before COVID hit, listening to Dean Erwin Chemerinsky say that the best way to convince or persuade a Supreme Court justice that some activity violates the Constitution is to suggest that it would apply to him or her.
I'm sorry, Judge Diaz. I didn't mean.
No, that's okay. I get the point. Thank you for that. And thank you, counsel, for your able arguments here this afternoon. The case has been well presented. We would, as you've heard earlier, typically come down and greet you personally. We can't do that, obviously, this afternoon. We hope soon that will be the case. But for now, we just leave you with our thanks and gratitude for a job well done. So thank you very much. I'd ask the courtroom clerk to adjourn court of the day.
Honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.